to the 3rd Annual Muslim Human Rights Conference happening today. We thank you for having made time for this event despite your busy schedule. We are really grateful. Right Honorable Speaker, Muslim Center for Justice and Law is a non-government organization which was begun in 2010, and our major aim is to advance access to justice and human rights promotion. Right Honorable Speaker, we've done this job for 10 years now. We've represented indigent persons in courts of law. We've advocated for gender inclusion. Right Honorable Speaker, we've engaged religious leaders at various levels, especially in the Muslim community, to see that access to justice is promoted. Right Honorable Speaker, this is the 3rd conference, and for today's conference, the theme is enhancing access to justice, addressing the question of the domestic relations laws in Uganda. Right Honorable Speaker, there is a question. There is a question why the laws which were drafted, which were enacted in 1904 to 1910, despite the fact that courts have made several changes, there is a question why we still have those laws. Right Honorable Speaker, there is a question why the laws pertaining domestic relations, that is the Marriage Act, Succession Act, and the Kadhi's Courts Bill, up to now are not being debated to their final conclusion, such that they benefit the vulnerable members of the community. Right Honorable Speaker, we do understand that without a proper law leading to justice, the vulnerable persons cannot get justice. We've tried, as Muslim Center for Justice and Law, with support from DGF, TROCRA, and other agencies, to assist indigent persons. But in most cases, when we go to the chambers of her worship, she will tell you to cite the law under which you are proceeding. She will tell you to cite the law under which a right is being protected. Right Honorable Speaker, we are saying that the laws are in place, have been washed down by the current constitutional reforms, and they have not been amended, and we think that it is high time that the laws are amended. Right Honorable Speaker, we are having panels of discussants and presenters. Amidst us, you found the first session was beginning, but because of the program, we put it at hold such that you can have your address. Right Honorable Speaker, we do welcome you to the 3rd Annual Human Rights Conference under the theme, and we are glad to receive your enriching deliberations. Right Honorable Speaker, Muslim Center for Justice and Law is delighted for the reforms that have been made so far by Parliament. The amendments in the Land Act that protect the rights of women, especially to do with the spousal consent before selling the matrimonial property, are highly welcome. Right Honorable Speaker, the changes in the Mortgage Act are highly welcome that protect the rights of especially women. But Right Honorable Speaker, we feel that the core laws, that is the Succession Act, Marriage Act, Marriage and Divorce of Mohammedans Act, which touch the core of domestic relations, still have to be amended as directed in several decisions of court and to suit the constitutional parameters. It is my honor to welcome you to this occasion. It is my honor to invite you, Right Honorable Speaker, to address us on this theme during today's conference. Thank you very much.
Thank you very much, moderator, and the Assembly of the Third Annual Muslim Human Rights Conference. It's a pleasure to be with you today and to know that a lot of work is going on. I welcome the judges of the High Court if they're here, the religious leaders, heads of the diplomatic corps, heads of government agencies, and the partners from civil society and the private sector, the media. Ladies and gentlemen, thank you for inviting me to be part of this noble activity where you address enhancing access to family justice, addressing the question of the domestic relations legislation in Uganda. The moderator the president has raised a few issues, but I think I wanted to really start with the issue of access. Do we have the necessary infrastructure throughout the country? Are they accessible to all? Are they accessible to the people with hearing and special needs people? Do we have lawyers that can speak to those people with special needs? Do we have a judiciary that can respond to the issue of special needs and speak to them in a language that they understand? This is something we need to think about. How far are the courts from the people, the target beneficiaries? If you're going to have to travel 40 miles to attend court, you must first invest money in that journey. You must invest time. The courts begin at 9 in many places. A litigant may have to come and spend the night near the court. All these are costs. All these are barriers to access to justice. So we need to address those issues. Now, again, the president asked a number of issues. I'm actually quite intrigued. I had expected that when the courts make their pronouncements on different aspects of our law, that the Attorney General or the Minister of Justice would move immediately to deal with that amendment. But unfortunately, that is not the position. For instance, we have a number of judgments that has been handed down in the Marriage Act on issues of grounds for divorce, etc. But they're still not statute books, and I thought that the Attorney General would move automatically to abide by the decision of the court. But it seems that we still have to go through the laborious process of enacting laws through other means. But who is in charge of making those changes? I don't know whether a private member can move all those amendments successfully, yet they're supposed to be implemented by the government. There is an issue of whether the proposed changes that we would make have a financial implication, have an implication on manpower. Who would handle that? So there is really a gap. There is a gap between what has been adjudicated and what remains on the statute books. I think for now we can only say we shall continue to advocate, but it's really a really hard struggle. For instance, as you know the history of the Marriage and Divorce Act, the reform of family law, since 1967, as a result of the Karema report, we are still struggling with it. At the moment, even the minister responsible is afraid to come to the floor to complete the bill. I've left it on the order paper, hoping that the minister will wake up and say, this is my responsibility, but they have not. So we all have these issues, and I think it's important that as a community, we raise these issues to ensure that they are addressed. The Succession Act There is a bill in the House. I'm hoping that probably after the elections, this period is a bit difficult, but I believe that between February and May, when the elections have been concluded, we'll be able to handle the Succession Act. And there are a series of laws proposed and pending under the Committee on Legal and Parliamentary Affairs. But I hope that as soon as we finish the campaigns and the elections, members will be more able to settle down and finish what is outstanding. Yes, there have been amendments to the Land Act and the Mortgage Act. Yes, some of it is working, because I've seen petitions and counter petitions on the application of this law. So I think it is a good thing. At least there's a small barrier. Someone has to think and also have to be able to graduate to the other side by getting consent or not getting the consent. So I think to that extent, some of those provisions are working. I've asked the Cadiz Court's law. I've not seen any bill to that effect. I know that the Constitution had indicated it as one of those that should be done within a particular period, but it has not come. And again, this is an area which really the government should handle, because it may involve appointment of judicial officers, it may involve creation of different infrastructure, and also the budget to manage those courts. It has to be provided for. So all these have not been done. So I think we need to lobby much harder to ensure that these are put into place. The only interesting thing I had, there was a time we talked about it, and then someone asked me, are you also going to establish the ecclesiastical courts? So, you know, we have all those things in our society. So I said, well, I know about that, but has not been addressed under the constitutional amendments, but that's what our society is like. So all in all, I think I would just ask you to increase the advocacy so that those who are responsible for taking action will do the needful. Otherwise, for me, I'm ready. I know that we have the will of Parliament, but we need the support of the other branches to enable us give access. I've been talking at length about the issue of the special needs people, both in the health sector, in education, and in the judiciary. I think it's an area where I think I also need support and advocacy from you so that we can handle our people to give them proper access to justice. Thank you very much for listening to me. I wish you a successful conference.
Thank you very much. It was quite insightful. And I'll take this opportunity to welcome and invite Mr. Ntambi Musa to come and give a vote of thanks towards that address. And thereafter, I would request that we will have a social distancing, programmed picture with the Right Honorable Speaker before she leaves the conference. Me inclusive, I'll be part of that. Thank you very much. Mr. Ntambi, please, thereafter we'll join the discussion.
Right Honorable Speaker of the Parliament of Uganda, religious leaders around, government agency representatives, civil societies, the panelists we have here, I take this opportunity also to add my voice welcoming the Speaker of the Parliament of Uganda, Right Honorable Rebecca Kadaga. You're most welcome to the third annual Muslim Human Rights Conference. Today, Muslim Center is celebrating 10 years of existence, and we are privileged to have you. It is a pleasure that you have spared time to be with us this morning, and we pray that the Almighty God enables you to go through whatever you're going through. This time, it is a very challenging time, and with a lot of hurdles ahead of you, that we pray that all the blessings that you've accorded to this assembly today should go with you as you aim to achieve higher. We thank you very much, and we pray that the Almighty God enables you and gives you the gift of life to see Uganda achieve what we aim at achieving. Thank you very much. We pray that the Almighty God can bless you. Thank you.
I would request that we just get a few representatives, then we'll get a picture with the speaker, and just a few representatives, and we'll also maintain social distancing. Thank you very much. The regional our discussants and panelists also, please. We are going to maintain, we'll also use the upper podium as low as the okay. Ladies and gentlemen, please, we are honored. Thank you very much for that program. Let us proceed with our program. Let me take this opportunity to welcome Dr. Zahara Nampeo again to have a continuation of the paper that she was presenting. Thank you very much.
Assalamu alaikum once again. The Right Honorable Speaker, although she's not here to hear me, is a friend of the Muslim community. I have attended events at Parliament during the Ramadan, and she's very supportive of the community. So we pray for the Almighty to continue blessing her kindness. As I continue, I had started on my paper by defining the concept of access to justice so that we all understand it. I was now talking a little bit about the Muslim community in Uganda, who we are, what defines us, what are those peculiarities or features that intersect with the concept of access to justice. So I was saying that whereas the Constitution of Uganda recognizes the practice of Islam as a religion under Article 29, thereby guaranteeing a legal recognition and right for Muslims to exist in this country. The Muslim community is defined by certain features that affect our enjoyment of the right to access justice. I pulled out a few of these. One is the low levels of literacy. Literacy in the contemporary English sector, if I may call it that, because we are learned in the Arabic arena. And especially, this especially affects Muslim women. And why is this important? For us as an academic, for me as an academic, the intersection of this factor of education is important because of what we call intersectionality. Intersectionality means that oppression is not in one form. It is not singular, it's not a singular process, but it is best understood as a multiple, converging, interwoven system that works together and brings with it multiple dimensions regulated by Sharia law and practice rather than statute. And the problem with this is that whereas we know about Sharia law, it is the guiding law, but there is always a challenge with not having a codified legislative framework. The problem of having this kind of structure, these kinds of courts, is that the interpretation of the law, of the Sharia law that currently governs Qadi courts, is subject to multiple interpretation. A sheikh in Arua will say another thing according to his interpretation about why women or children should access Qadi courts. Another one in Bundibujo will say another thing. So that multiple lack of consistent interpretation and application of the rules of Sharia, whereas we claim and we do actually know them. And of course also the biases. We are all part of a community. We all come from different parts of the country. We are not isolated from our cultures. It should be noted, for example, that the number of cases filed by women in Sharia courts is very minimal compared to that by men. What does that say? Are there instances where a woman approaches an imam and the imam says, but you've come here 3 times, you go and sort the issue with your husband? Has he given her that avenue to listen and say, maybe this is a case that should actually come before a formal Qadi court? It can no longer be handled by mediation. Another example, we know the Sharia rules on evidence of men and women, the evidentiary rules that discriminate between men and women. For example, in cases of adultery, you require, I think, 4 women to 2 men. And, adultery is part of marriage, it's part of what we are allowed to deal with in the Qadi courts. That is a problem. The lack of record in order for us to use the appellate system within the formal court, that is also a problem. Are we recording? Are we able to record the proceedings of the Qadi courts? The lack of scrutiny of the Qadi courts, the shielding of the operation of these courts. For example, right now, the Justice Law and Order sector, tomorrow, Thursday, the 26th, is undertaking its annual review of performance of justice institutions. Qadi courts should be part of this public scrutiny to say they received this following number of cases, these are the issues, this is how they can be strengthened. But because there is that lack of a legal framework, we are disadvantaged in order for us to improve the functioning of these courts. So that is a bit about the context in which we enjoy and experience access to justice in Uganda. Now, as I get to the domestic relations law, and I know that the paper has to be discussed, let me start by flagging out a quote by a US Supreme Court judge He said, equal justice under the law is the most inspiring ideal of our society. Justice should be the same. Justice should be the same in substance and availability, without regard to other status, poverty, marital, etc.
Doctor, I know your presentation was interrupted a bit, but you've got 5 minutes to wind up your presentation.
Thank you very much. Now, if I can highlight some of the problems with the marriage and divorce law, and in particular, I'm concentrating on the Marriage and Divorce of Mohammedans Act. As the president of MCJI mentioned, this is a law that is so old, it has not benefited from a single amendment. For example, it still talks about a penalty for failing to register a marriage. And yet the law, the courts have since moved on from requiring registration. If you don't register according to the court precedent, it is not fatal. So that is something that you can see that we still have the Mohammedans law, but it is not up to date with the reforms that are happening in the courts. The lack of detail. If you look at this Mohammedans Act, it is so thin. It just says that everything relies on Sharia law. But how many of us can actually interpret Sharia law? So the lack of substantive detail, the lack of codification affects access to justice. On issues such as defining the components of marriage, being clear that a marriage requires consent, it's free, mutual consent, the eligibility of people to marry, soundness of mind. We need all these things codified so that they can be better interpreted and applied. I know you look at the paper, but I just want to pull out also some other issues which I hope will prompt discussion later. The issue of maintenance of spouses after dissolution of marriage is also something that is not touched upon. But more importantly, and I'm putting this out deliberately so that the religious leaders can voice themselves, the issue of cohabitation. Come, we live. For my students, I call it friends with benefits. You come, we stay in the hostel or whatever. Then after the hostel, you go and stay in the community as husband and wife. No legal marriage, no nikah, no nothing. It is happening. Imams, this is happening. 64% of people in Uganda are living in cohabitation. But we can't run away from it and say it is zina. Yes, it is zina. But if we're talking about access to justice, how does the law affect property and rights of this man and this woman in this unlawful religious relationship? What about the children? So after 20 years, they all go their own way. No nikah, they were not married. What about the children? What about the rights of this woman who is now 53? What happens to her? And the courts have gone ahead and pronounced themselves to say, for example, there's a case, Hajat Nuriyat Chiwanka versus Microfinance Support Center Limited. It says that when a question arises whether a marriage has been contracted in due form, unless the parties were prohibited from intermarrying, maybe through being related by marriage or clanship, it is presumed that they were actually validly married. So that's what the law is saying. Can we have a pronouncement, at least in our laws, in the Mohammedans, at least to prohibit and disqualify the practice of cohabitation? Chairperson, as I finish on divorce and matrimonial property, the Marriage and Divorce of Mohammedans Act has also not helped us. And we have seen many cases of Muslims fleeing to the civil courts to seek justice because of the silence of the act of the Muslim law on issues of ownership, substantial contribution. Who contributed? Do you have to contribute? Equitable interest. The courts have said in Uganda right now, the courts are saying that women, especially women, contribute to marriage in various ways. The case of Chintu versus Chintu, which quotes a Kenyan case, Justice Omolo, it says that women contribute to marriage in various ways, including giving birth. you know, having children and nurturing children is contribution. So when you're, dissolving the marriage, those are factors that should come into consideration, even if the woman stayed at home. So recognizing the economic value of work of women at home. And of course, our constitution is very clear about this. Equality in marriage, equality at marriage, equality at the dissolution of marriage. So we should be guided. We shouldn't be left behind as the Muslim community to say that for us, Sharia law is very clear. Sharia law says you can marry 2 or 3 or 4. But if you will not do them justice, then marry only 1. Can you sheikhs come together and tell us what is justice? Does justice mean that you must provide a separate house for each person? You must have economic means? You must look after the children? Because some countries, such as Morocco, have gone ahead to regulate on issues of, for example, polygamy. So we need to also see how we fit in, reconcile our Sharia law, but also try and protect parties. As I finish, Chairperson.
Please conclude.
Let me conclude and say that the domestic relations law in Uganda, regulating Muslim affairs, has the opportunity to ensure justice to all members. However, it needs to add more detail to its thin provisions. There is need to adopt human rights norms and standards which do not contradict the teachings of Islam, and yet at the same time which ensure justice and access to justice for all members of the Muslim and non-Muslim community. And I want to single out the words of Martin Luther King, who on issues of adjudicating matters involving members of the Muslim population. He says that justice denied anywhere diminishes justice everywhere. We should aim to do justice to all members of the Muslim society. Until then, the common Muslim family remains vulnerable, especially the women, and susceptible to gross human rights violations, and women take the heaviest blows. I thank you very much, and I hope that I have been adequately provocative.
Thank you very much for that wonderful presentation. Now it is time for the discussants to take on the conversation. I'm going to have Her Worship Patricia Amoko to take on the podium. You were expected to be looking at these specific issues in the presentation. How does court handle matters from the Sharia court, and what are the practical challenges in adjudication of matters involving Muslim personal law? And number 2, do you consider it necessary to get an expert on Sharia to give an opinion into court on matters of Muslim personal law? Those are the aspects I would do, you'll be required to address, and then others will address other aspects. Thank you very much.
Thank you very much. Thank you very much, Doctor, for your adequate exposition on the subject. I will go straight into the questions that the Chair has pointed out. Concerning the first question, I was not informed of what the court meant. I suppose this was by design. However, because the question stated matters from the Sharia court, the assumption was that one having been dissatisfied with the decision of the Sharia court wants to go to another. Then what? In matters involving children, that is in instances of maintenance, custody, declaration of parentage in the formal or secular courts, the assumption these matters are heard by grade 1 courts, grade 1 magistrates and grade 2 magistrates sitting as family and children courts, and the appeals therefrom lie to a chief magistrate. Issues relating to dissolution of marriages, property rights, succession are heard by the High Court if appealed against from any of the magistrates' courts. The lawyers here know that the right to appeal, as with jurisdiction, is created by statute. It therefore begs the question, though Kadi courts are provided by the Constitution, what is the law governing the procedure therein? What are the rules by which one dissatisfied by a decision therefrom can be governed in order to appeal to the next court? I am a judicial officer and I do not know where these rules are. Unlike in instances where it is more clear, for instance, in where the industrial court can hear a labor dispute by reference from a labor officer, the lack of codified rules presents room for different rules of application by different judicial officers. Dr. Zahara has pointed this out in her discussion, though albeit in a different context. The discussion points out how, for the most part, women are marginalized when it comes to property rights. It is no doubt possible, therefore, that different parties to a matter can prefer different systems that support their causes more. A woman seeking the guarantee of her rights as provided in the Constitution may prefer to have her matter heard by a magistrate, while her husband may prefer to have the same matter heard in an informal system hinged on historical and religious beliefs that would more than likely leave him wealthier than the formal or secular court system. I have therefore wondered while reading Dr. paper what options exist if, for instance, a petitioner to a divorce petition preferred to file a matter in a magistrate's court having jurisdiction, which is possible, while the respondent, well knowing their marriage was conducted under Mohammedan law, preferred to use the Sharia court, which he or she is also well permitted to do. If such were raised as a point of law by Councillor Nakachwa seated over there before me, the questions in my mind are what informs the court's ruling, on which court system takes precedence. Do the systems run parallel to each other? Are they mutually exclusive? What does a court do when posed with application of different substantive regimes at loggerheads with each other? Notably, for example, Article 31, Clause 1, Paragraph B of the Constitution grants men and women at entry, during marriage, and at its dissolution equal opportunities, equal rights, yet Sharia law, if applied to the letter, could result in disproportionate distribution of property to women at succession. Limited and non-robust precedents in a system heavily dependent on them does not make matters any easier. Can courts ignore Muslim litigants who want to follow Mohammedan law to the letter in pursuing their rights, even when in doing so, some provisions of the Constitution are being contravened? If yes, how is that position reconciled with Article 126, Clause 1, which states inter alia that judicial power shall be exercised by the courts in the name of the people and in conformity with law and with the values, norms, and aspirations of the people? As a court, if I am supposed to acknowledge the norms and aspirations of the Muslim community, how do I do so when the same law, Sharia law, might be contravening the Constitution? If all that the Muslim community can rely on in answering these questions in enforcement of human rights in domestic relations at this time is the activism of courts, which is a highly subjective parameter, are not many likely to be disadvantaged. How the courts handle matters under Sharia law or from those courts is, for reasons highlighted in Dr. Zahara's paper, and questions posed by this discussion, in my opinion, muddled with uncertainty, with no answers cast in stone. I was asked to provide answers, and I too, after reading Doctor's paper, have very few. Challenges beyond substantive and procedural legal questions central to the handling of cases, central to the access to justice, are also important. Do countries in the country have the adequate support system to permit easy access to justice by all Ugandans, by Muslims? For instance, are there interpreters able to aid court proceedings in cases including domestic relations? I think very easily of communities in the northwest of Uganda, for instance, at Jumani and Moyo. Those are communities where there's arguably a larger than average Muslim community given the influence of South Sudan. There are over 6 spoken dialects, some are not local languages, and yet you'll find a court having on average maybe an interpreter that can speak only 2 local languages. How can I preside over a matter where I understand nothing? Is that not sufficient reason to adjourn a matter over and over because I do not have an interpreter who can help? Whereas many courts would love to provide child-friendly spaces to hear cases involving children, many do not have the space to do that. In a similar vein, courts do not have the facilities to embrace e-hearings of cases. Worse still, as recent times have shown, the high illiteracy levels in both the Muslim and non-Muslim community alike have shown that ICT in adjudication of cases is not everyone's cup of tea. Ignorance of court procedures that Dr. Zahara talked about, the few advocates in the Muslim community as opposed to other faiths mean that oftentimes parties are not represented in court. That means that many judicial officers will be seen to descend into the arena, which they ordinarily should not be doing, as there can be a perception of bias that comes too easy. Cases involving Muslim personal law are no exception to being victim to other challenges faced by the judiciary. Cases may not, in some instances, be as hard as fast as they ought to. There's a rising population not met at all by the commensurate rise in number of judicial officers, which no doubt affects disposal. I'll give an example of the chief magisterial area that I had. With over 1,700 cases in the system, we are only 3 judicial officers, and I would like to say maybe 2.5 because I'm supposed to circuit and hear cases in other places. Lone chief magistrates at the moment exist in areas of Toro and the Langwa sub-region. So you'll find that one case on average takes over a year when it ought not to. Definitely not ideal if we're talking about what access to justice is. Each of you has the right to a fast and speedy hearing guaranteed by the Constitution. In times of the COVID-19 pandemic, administration of justice has not been any easier. Courts can only handle a given number of cases at a time, making litigation slow and painful. Are all or even most judicial officers equipped with the knowledge of Sharia law and its different texts to give room and effect to the norms, values, and aspirations of the Muslim community? My quick answer is probably not. To this end, I answer the second question in the affirmative. Under Section 43 of the Evidence Act, an expert could be helpful to guide a court in a case on matters concerning Sharia law. It should be noted, however, that a challenge would still arise in a setting where each side presents one purportedly an expert, yet presenting different findings. As in all other instances concerning expert evidence, the opinions of such experts will still remain persuasive to the court, as opposed to binding. In conclusion, therefore, whereas I have presented several challenges, these all present opportunity for better. As we sit here to discuss and scrutinize the challenges and loopholes that we face as the Muslim community wants to access justice better, let us look at things from the perspective of stakeholders in the justice law and order system, being stakeholders, but also from the perspective of being citizens of Uganda. And let us do our best to enable each one of us to enjoy rights as guaranteed by the 1995 Constitution. For God and my country.
Thank you very much. There's a round of applause. Thank you so much for that. I just want to remind the other discussants, each of you has got 20 minutes of discussion. So when you plan, put that in mind. And I shall be reminding you at the close of, before the lapse of 5 minutes. Then we'll be able to 20, yes. So I want to bring on another discussant. This is Dr. Abdul Hafiz Walasimbi. I want you to be, you're required to be addressing issues of gender responsiveness in the Qadhi's court system, and then access to justice for women and children under the Qadhi's court system. Those are the areas you expected to be addressing in your discussion. Thank you.
Bismillahir Rahmanir Rahim. Alhamdulillah. والصلاة والسلام على رسول الله وعلى آله وصحبه وسلم. Mr. Chairman, Madam Presenter, other discussants, the management and administration of Muslim Center for Justice and Law, dear honorable participants, allow me to salute you with the best salutation. Assalamu alaikum wa rahmatullahi wa barakatuh.
Rahmatullahi wa barakatuh.
Since the time is so much limited, I want to start by congratulating Dr. Zahara for doing justice to the presentation of this paper. I agree with her that access to justice, it is still a very big challenge up to now, even in the conventional civil courts, as she has made it clear. There is therefore need for deliberate and concerted efforts to address this challenge from all stakeholders. I also wish to agree with her on the statistics that she brought about the Muslim community in Uganda. I wish to agree with her that the Muslim community, up to now, it is still suffering from the historical discrimination by colonial masters. And it is because of this discrimination that you see it trailing behind. But on the side of Muslims, I don't want this to be always an area of lamenting and consoling ourselves. Yes, we lost our right to the secular education because the choice by then was very clear. You either join the secular education, and chances were high that Muslims are likely to lose their faith, or stay at home. So our grandfathers chose their children to stay at home because they wanted to preserve their identity of Islam. And to them, that was very great. So we don't have to be so much worried about that. Yes, the small number of Muslim institutions, as have been identified in the paper, it might be worrisome. But my call to the Muslim community is, we shouldn't be much concerned about the numerical weakness or disadvantage. Our emphasis actually should be about the quality. You all know that majority, yes, it matters, but you know the Quranic verse, وَإِن تُطِعْ أَكْثَرَ مَنْ فِي الْأَرْضِ يُضِلُّكَ عَنْ سَبِيلِ اللَّهِ. If you go always by majority, you might find yourself being misled. So our concern should not be to lament about the history. We should be actually focusing on the present and see that, yes, we are a minority, but how can we be strong, especially by producing quality work. Now, this brings me to access to justice in Qadhi's courts. Yes, the Ugandan Muslim community is a minority. And when I was reading Dr. Zahara's paper, this minority factors calls for special attention. It would have been actually an affirmative action. But what we are seeing actually is that there is little concern about this minority. And this has been seen like as early as 1995, Article 129D, it provides for Qadhi's courts. 24 years down the road, there is nothing that has been done in order to see that these Qadhi's courts are operationalized. The same happens to the regulations on Islamic banking and finance. They have been passed, and the question remains, why is it that we have not seen this into practice? Now, this brings me to also address the issue of there is a certain source that Dr. Zahara was quoting. It's about Law Uganda on Qadhi's courts. It has presented the Sharia as a source of laws and beliefs which are discriminatory. But to me, this is an opinion that maybe comes from a non-informed position. Why am I saying so? Those who are looking at Sharia from their perspective, they are actually ignoring one fact, that if we use the same legal analogy in secular law, you have ranks. Her worship has been talking about, starting from grade 1, grade 2, you have the magistrates courts, you have the high courts, then you go to the Court of Appeal, then you go to the Supreme Court. My dear, it is not just a matter of coming and look at the Islamic law provision and you satisfy yourself that you have understood it. They are always experts. So these laws, which might be seen actually as discriminatory, I can assure you that when you involve experts, you might find it otherwise. So the secular law, in many cases, it looks at the spirit instead of the letter of the law. But when it comes to Islamic law, actually, very many people who study Islamic law or Sharia laws, they are just concentrating on the letter of the law. Yet, in this era, we are talking about the maqasid Sharia. We are talking about the higher objectives of Sharia. If there is a law in Quran which says this, we are not concentrating on the letter of that law. What was the underlying spirit? What was the underlying objective behind that? Once we take that route, I can assure you that we shall reach an agreement between secular law and the Sharia laws. Now, for instance, in her paper, Dr. Zahra's paper, she talks about the chapter 4, verse 34, which is like giving the Muslim man, much leverage in family. But what is the interpretation of it from a Sharia perspective? My concern is, yes, it says, الرجال قوامون على النساء. Men are protectors of women. What does protection entail? Is protection a privilege or a burden? These are some of the questions that we need to ask ourselves. The other concern is, why don't we read that particular verse of Quran together with chapter 9, 71, which says that women are always companions of men? Why don't we also extend it to another chapter, that is Surah Shura 42:38, which says, وَأَمْرُهُمْ شُورَ بَيْنَهُم. Their affairs in a family, in an organization, it is an affair of mutual consultation. Why don't we read that same verse together with the Prophet is saying that النِّسَاءُ شَقَائِقُ الرِّجَالِ, that women, whenever they are always together with men. So these are some of the issues that need to be brought to the experts so that experts actually can bring out the true position of Sharia. In other words, that protection that is given to men, it cannot be taken as condescending. It is not to be supreme or what. Now, inheritance. Yes, in her paper she talked about the inheritance of illegitimate children, and I also want to address quickly about the unequal shares to women as per the Islamic law of inheritance. First of all, I have written an article on this, and inshallah very soon it shall be out. I'm finalizing it. However, this issue of illegitimate children, it has a background. The opprobrium of illegitimacy, which is suffered by children who are born outside the marriage. Yet, all of you Muslims, you are aware of the verse which has been repeated 5 times in Quran, which says, وَلَا تَزِرُ وَازِرَةٌ وِزْرَ أُخْرَى. No any soul shall be taken to be responsible of a burden of the other. So this child is out through illegitimate means. How are we supposed to address it? The Sharia approach is, yes, this child might be denied inheritance from the father, but it has also given him the right to inherit from the mother. And when we are talking about women emancipation, I can assure you that women these days, their financial muscle is higher and greater than that of the husbands. So there is a likelihood that this child can inherit more from the mother's side. That is one. 2, Even if this child is denied inheritance from the father, but also that father has an obligation to take care of the provisions of that child. That child is out. Whose responsibility now? This is your blood. So Islamic law comes in through the Maqasid Sharia, and it makes it your obligation to take care of your burden because you are the one who brought it. Secondly, this child can all be catered for under the will. The will in Islamic law is different from the will or the tested will in the secular law. When I am dying, for instance, I can write in my will when I have an illegitimate child that such and such property, it should be in favor of my child. And that one can cover up or can mitigate the fact that this child is denied from my inheritance. But also, as I conclude on this matter, why do we think that inheritance is like the capital for socio-economic future? All of us have not succeeded because we inherited some estate. Not at all. But it's like there is a lot of emphasis if he does not inherit, if he does not inherit. Yes, all these issues have to be addressed so that it can be clear. Now this takes me to the justice of women before Qadhi's court.
You have 5 minutes, Doctor.
Thank you. I'm finalizing actually. The issue of women inheritance. The unequal shares. You know, when we talk about these unequal shares, first of all, we forgot the wide social setup of the Islamic society. But let me give you some few statistics here. There are 11 cases where a woman in Islam inherits what is equivalent to the man. Also, there are 14 cases where the woman actually inherits a bigger share than a man in the same law. There is also 5 cases where the woman inherits and actually the man is excluded. It is only 5 cases where a woman inherits what is less than a man. My conclusion, Mr. Chairman, is that I think, according to the presentation made by Dr. Zahara, is that we are now suffering from what we call legal pluralism. The same constitution grants us as Muslims the right to freedom of worship, but at the same time it restricts us. All those matters that I have talked about, inheritance, property, these are issues of worship in Islam. And therefore, if you have granted us freedom of worship, why do you curtail us from another side? So, in order to harmonize the situation, I agree with her worship, there is need to bring the Sharia experts, the secular experts on board, so that we can actually see how best can we move on. We are citizens of Uganda, but we are also citizens of Islam. I thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Thank you very much for that wonderful, discussion and introduction. From what is emerging, I think you all can see the relevance of the Sharia of the Qadhi's courts. Really, if this were to be in place, all these questions would be answered. All right. I don't want to become a discussant, but I strongly feel that is one of the ways that we could go, advocate for and have those courts put in place. Once they're there, then you have no burden. All right. All cases that are, of this kind should be sent to that area where there will be experts from the lowest level of court system to the highest level of the court system. I know the Honorable Speaker of Parliament said the costs involved, but that's what the country has to bear. That's what the government has to bear for us as a group of people, good citizens in this country. I want to bring on stage the third discussant. This is Councillor Nakachwa Sarah, and her area of interest should be surrounding as a practitioner and Muslim woman, what challenges do you face in handling cases involving Muslim personal law? Emphasis on evidential requirements in proof of marriage and grounds for divorce. That's the area where you would want to be concentrating your discussion, and then afterwards we shall have to go into the plenary session. You've got 20 minutes. Thank you.
Bismillahirrahmanirrahim. Protocol observed. Assalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu wa rahmatullahi wa barakatuh.
I applaud the previous speakers. Dr. Zahara, thank you so much for the justice done to the topic, and all the other discussants. I think from their discussions, we have all been poked. We are all scratching and there are questions going around. But as stated by the keynote speaker, I think as lawyers, we equally face very many problems in trying to address issues relating to Muslim personal law. As Her Worship Amoko stated, there is no codified law, especially in relation to issues relating to Muslim personal law. So as a lawyer, what is your obligation if you are faced with matters relating to Muslim personal law? Oftentimes, I think as Muslims, we normally choose in terms of marriage to go with the Islamic mode of marriage, okay? And I think naturally it should flow that even at dissolution, that is the mode that we should use, okay? However, what happens in a situation where there is no law to rely on? As a lawyer, you're not an expert in Sharia, because from what my brother Dr. Hafid has presented here, okay, every topic oftentimes is best understood if you have had that time to study and research the same. There are so many justifications as to why women and children pertain in different shares during succession. However, as an ordinary Muslim that is not schooled, okay, that is not schooled in Sharia, how do I understand that? How do I help a client that comes to me and seeks to have a share in Sharia? Oftentimes, personally, if I get matters that relate to Muslim personal law, I think from my interaction with Sheikh Paso, that is the registrar of Muslim Center, I normally refer, okay? But it is not also in all matters that I refer to him. In questions where there are issues of property distribution, for example, upon divorce, oftentimes as a lawyer, I will elect to go to the conventional courts, because that is where I know my client is better placed to plead their case and have certain property rights. Most of us that have done a bit of Islam know that when you are divorcing or on divorce, we are told in Sharia that a woman is entitled to a gift from a husband, okay? That means it leaves me at the mercy of my husband, and this is the worst time of marriage, dissolution. So what do you expect from a husband from whom you seek to divorce, okay? If you are left at their mercy. So these are the issues that we are talking about that need to be codified. How do courts look at this gift? What factors determine the gift, okay? Indeed, you will find a man who for the longest time, you've been together for 30 years, and when it comes to dissolution, he's saying, what did you come with anyway, okay? This woman seeks to steal my property. So out of his billions of shillings that are coded to his name, he will say, I am giving her 5 million or 2 million, or some are saying, okay, there is a piece of land somewhere in the village, I give you that. Okay? 30 years with a man, and that is all you're entitled to. And sometimes, remember, divorce, by the time I seek out of a marriage, it is not out of comfort. This is something that has been caused by the very person from whom I'm seeking a gift. Okay? So, as lawyers, we face so many problems, but oftentimes, like I've said, some of us will elect to go to the conversion courts, and oftentimes that is where issues of proof of marriage will arise, okay? And this is the first problem, or the biggest problem that we get as practitioners. How do you prove an Islamic marriage? 50 years ago, 40 years ago, 30 years ago, most of our parents do not have marriage certificates. Some of our sects in Islam actually do not allow you to take photos. So there are no photos as well. This time, it is my word against my husband's word. Okay? We are married, the man says, no, bring proof. Simple. Sometimes your relatives are disinterested in being engaged in your dissolution of what? Of marriage. So you go to court, the man is asserting A, the woman is asserting B. What do? And court is saying, we work with proof. Prove you are married. Okay? The other issue that we face as practitioners is that sometimes even when proof is available, okay, we know that some of our sheikhs are not very literate. You have a marriage certificate that is so questionable that you as a lawyer, okay, cannot rely on it. For example, I'll give you an example. There was a time I was handling an issue of succession, and there was an issue to do with whether one of these women was a wife. This woman goes to a sheikh, the man I think died about 20 years ago, goes to a sheikh, and the sheikh issues him a marriage certificate with a deceased on it, with a date, on a date where the person had since passed on. Okay? So I do not know what this woman told to this sheikh for him to give him. Indeed, on the certificate itself, in brackets, there was deceased on the husband. So as a lawyer, you ask yourself, so how do I rely on this? Okay? Good enough for me in that case, it was something that had been brought by the other party. And of course, that case should have been a piece of cake, really. Okay? If you're proving a marriage by way of fraud, how do you? Okay. Then the other issue, like we've all stated, is non-codification of these laws, really. Okay? If laws are not codified, like Dr. Nampeo said, there is a lot of room for error and abuse. Oftentimes, personally, I don't practice in Qadi courts because I ask myself, what am I going to deliberate there? After all, the expert is the sheikh. So it means personally, I'll also be waiting for the verdict from the sheikh, because I am not schooled in that scope. However, had we had something that tries to codify an amalgamation, certainly it would have been easier for me to bring out my human rights card and wave it in the face of the sheikh. In the absence of that, you do not have so much to do in those courts. Okay? Then the other issue is, like the doctor stated, not documentation or lack of records by these courts sometimes. Okay? You have a client who goes to the Qadi courts, they get a judgment, and after judgment, the other party is dissatisfied. Okay? And the question is, how do I transmit the record from the Qadi court to prove to court that this matter either has already been decided upon or for purposes of appeal? Okay? I'll give another example. There was a matter still as handling in Machinge sometime, and there had been a decision by the Qadi court of Uganda Muslim Supreme Council. So what this woman did after this decision, she ran to court and applied for divorce as well as custody of kids afresh. But we already had a decision. You know that she had already subscribed to the jurisdiction of the Qadi court, and indeed the case was heard. However, she went to court and said, I seek to have custody of my children and also divorce as well.
You have 5 minutes, ma'am.
Thank you. And personally, when I went to court, my issue was this matter is res judicata, because it has already been heard. The magistrate overruled me. Certainly, I sought for a record to appeal. And I think because of the fact that sometimes, like we said, even our judicial officers do not know what to do in these circumstances. This record 4 years later has never been availed of the ruling for me to appeal. And because I already have a decision that says marriage was dissolved and children in my client's custody, and none has been done to remove them from him, certainly I am quiet about it, because I tried to follow up and the same was not. So you look at the confusion that goes on both at the bench and the bar if we are trying to look at issues involving Muslim personal law. Then the other issue of appeal, like we stated, at what level are these courts, Qadi courts, are they parallel to the magistrates' courts? Are they at the same level as the High Court? Where do I appeal? Okay? Like our worship rightly stated, an appeal is a creation of what? Statute. So what happens if there is no statute directing me to where I will go? Nevertheless, the courts are in existence and operating. How do I proceed? So that is why you realize that in most of these cases, it is either the litigants who decide that I will not go for appeal, or in cases, for example, where you have to enforce maintenance. So what do? Do you go to the Chief Magistrate's Court for purposes of enforcement of this order? Or do you go to the High Court for purposes of enforcement? Since our sheikhs do not have the tools, because we all know family cases are those recurring cases. If someone is given maintenance, this year the man will pay. 2 years down the road, he will not pay. So where do I go with my order to ensure he continues to pay for maintenance of his children? Okay? So, like the previous speakers have said, our appeal is that we should have these laws, first of all, codified. We have a streamlined process through which the Muslim personal law, or through which you seek remedies in case you have been aggrieved. But like they say, Rome was not built in one day. I am grateful to Muslim Center for Justice for these engagements and continuous probing to ensure that these laws are codified. Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh. Thank you very much. Now you've heard from the panelists, from the discussion. The presenter has done her work and the panelists have also yielded. Before I open this discussion to the floor, even to the plenary, make some observations. Number one, I think this is the right forum to throw two challenges. Challenge number one is from the paper I read and the discussions that have been prevailing. It is quite clear that many of the Muslim lawyers think because they are Muslims, they should know the Sharia, which they have not yet read. That's not correct, all right? I don't see why you don't go out there and read. I mean, Islamic University is there. Why don't you offer a diploma in Sharia law so that you can really be on firm ground to go and defend some of these issues? Number two is you talk of proof, even it was here in the paper, proof of evidence of marriage. What do you think proof of evidence should be? A certificate only, a record. It doesn't have to be a record. As a matter of fact, a Muslim marriage cannot be valid without witnesses. People were there. We saw you married this woman. Four, not only one, four. Marriage in Islam is a public affair. Witnessed. Don't witnesses bring evidence? Is there not acceptable evidence? So, why do you think it's very difficult to prove? Because there are no records. I mean, people are there. This one has been taken off by Sharia. Right? No marriage can be valid in Islam without four witnesses. whatever, 2 witnesses, whatever. But it's a public affair. Abantu abali kumbaga. Can they come? Abali kumukolo? They should come and say, yes, we saw you married this woman 40, 50 years ago. You know, my late father celebrated, 50 years of marriage, 10 years ago. And there were people who came on the function and they said, we were there at the wedding. So what other proof do you need to prove? Now, the issue of codification. I don't know how much research you Muslim lawyers do when you're confronted with this kind of cases. Sharia is not on Mars. It is applied everywhere in the areas where it is applied. Why don't you do research and cite those laws? I have seen some cases where people are citing a law in India in the common law. Why don't you cite those cases before you go and, claim for the codification which is not going to be coming by? This would be one of the areas that you could go, it's a route you could pursue. Go and look at those cases where Sharia is ruling. What are the practices? What kind of judgments do they make? All right? And then you refer to them. So that was the first challenge I wanted to throw. The second challenge I want to throw to especially to the Muslim Center for Justice and Law, is a philosophical one. I just want you to think, not today maybe, but think about this. What comes first? What is the principle between justice and human rights? What's the principle? Do we have justice under human rights or human rights under justice? I saw a lot of writing in the paper assuming that if we were to put a hierarchy, human rights would be above, justice, which I think is not the case. I know some human rights activists may not agree with me here, but I think justice is superior to human rights. And therefore, when we have this kind of dialogue, what do we pursue more? All right? I liked, I think, the lady from Hill. In my opinion, those people have got it right. They would rather pursue justice, because justice is justice across the board. Every community, every country, every culture has a meaning for justice. But some of these local communities in Uganda and in other places in Africa, they even don't know what human rights are. You ask them what is human rights, they don't know. But justice, everybody, they have mechanisms of justice. That's why we have got an African Charter on human rights. Now, why do we have that one besides the general one, the Declaration of Human Rights? So it's an interesting debate, all right? But as Muslims, I'm talking to the Muslims, I think you need to look at that. Chichiche Tusoso was, what do we take as the principle that should be pursued? I think it should be justice and not human rights. Because you all know human rights has been authored in the Western culture and civilization, and our experience in the historical process, meaning us Muslims and the Western countries, the Western civilization, our experience in the historical process has been not the same. So we can't have values, we can't arrive at values simultaneously in the same way. But I know for a fact justice began much, much earlier than when we came to understand or to think of human rights, which are recent, just being codified recently in 1948. Anyway, that was my contribution to this, to the discussion, to the debate. But now I'm going to be opening the floor to the community, or to the audience. If you want to say something, you can put up your hand, and then do we have 10 minutes?
Yes, we are going to, I think I'll request the technical team to avail us with a microphone.
Okay.
In case someone has a question, they're going to raise their hand. To be precise, you're going to forward that particular question. If it's an observation, please make it. And if it is okay with you, please introduce yourself. Forward it to the particular discussant who made the comment. There are quite a number of them, but I would also request the technical team still to open the discussion to our online participants. In case there is anyone who wants to make an observation or a question or anything like that, they are welcome to make to raise their hand, of course, and be part of this discussion. We will be reacting. I think the chair will accord time for the answers, sorry,
10 minutes.
the reply to be made.
10 minutes. We can take on, I think, about 5 questions.
Okay.
We're not going to be here forever.
Thank you.
5 questions.
I would request one of my colleagues to please help me move with the microphone. There is a lady there who would like to, yes.
I hope you are not doing my work, eh?
No, I'm not.
Okay,
I'm not.
let me pick them.
Please.
And then, so that I can feel the power.
Thank you very
Okay.
much. Dr. Zahara,
Yeah,
the
I
discussants, the chairperson, the moderator, Muslim Center for Justice and Law for organizing this very important dialogue. My name is Kara Shemeri from Center for Domestic Violence Prevention. I want to agree with all of you and to feel the pain that we go through when you're trying to access justice, especially for women and children who are indigent. My contention, however, is related to the Muslim personal law. I remember when the debate on the marriage and divorce bill was very heated, one of the contentious issues was related to the Muslim personal law, which we were trying to put into this bill. And the Muslim community came out and said they would rather do their own. So we thought actually that process was moving forward because it's one of the deliverables we have to take forward for the marriage and divorce bill to move forward. So I'm directing it to all of you because I don't know who is responsible for this, but we know that this is one of the things we need to move forward to enhance access to justice for women and children, especially related to family justice. Thank you very much.
Yes, since you didn't direct it to anybody, I shall assign somebody to answer that. Dr. Zahara, handle that. Okay. Down was the lady. Yes, the gentleman here. The gentleman with the colorful mask. With the mask, with the colorful mask. He's properly dressed, yeah? You know.
Bismillah.
Yes.
Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillah, all protocol observed. I thank Dr. Zahara. You have done us.
Can you go straight to the question?
Thank you.
Yeah.
It's more of a question and an observation on 2 aspects as a practitioner. While Councillor Nakacho was highlighting a fact to do with codification, I think our worries were most entrenched on the procedural aspects. How do we go in? How do we go out? When we are cut our legs, what do we do next? So when all our minds should be the procedural part of the card courts vis-a-vis the parallel system. Then Dr. Hafiz did us great when he defended Sharia law. Yes, I must acknowledge the fact that those who have been schooled or those who have been given a chance to school in Sharia, it has been legislated. We have heard the Quran, we know the Hadith, there is a lot of
Can you ask a question or make a comment and sit down?
Yes, I'm finishing. And we know the chaos. To the professor, while you are giving your aspects on the entire discussion, we should, as Muslims, not forget the setting of the Muslim society. We have a setting where people come into your house. You have your girl, you sit. They seka woman tuwo muwala. You do your things. 3-5 sawa kumi. Our brothers in the Tabligh community do a lot of that. They are no witness. You didn't even call your neighbors. That's the reality that hits us hard. Those same people, 10 years, they come, they knock on your door. They need guidance. Seka Umar is dead. Mwalimu wokuchalo yafa. But these are the people who gave out the girl. So, as we address these challenges, we should also understand and appreciate the unique setting of an Islamic family and an Islamic culture. Once we embed those two, they are the ones we need to codify into the procedural aspects of dealing with Muslim property law. Thank you very much.
Welcome. I want to pick another one from that side. Yeah, there's one hand there. Those are 3 questions so far. Then afterwards, I shall come to you, sir. Then lastly, it will be the lady, and that will be it. Too late.
Naam, assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.
Waswa Omar Muhammad, I work with the Uganda Muslim Council. I am the Administrative Secretary to the UMS Electoral Commission, but also a practitioner in these community development issues. I'm also a product of MGCL. I really appreciate your efforts in these issues. Yes, the chairperson, you are giving us only 10 minutes, but I think this topic, as you have witnessed yourself, 4 presenters you have.
Can you ask your question instead of taking a lot of time?
Looked at it, and it is not easy just in 2 minutes to handle. However, I would sum it up like this. Perhaps we are, it's like you are rushing the situation which was not ready. For example, in 1995, the framers of this constitution, under Article 129, they said there should be a Qadi court. But after saying that, what happened? The Muslims rushed to say, we want our Qadi court. The questions which were posed here by the Right Honorable Speaker and the presenters here are actually pushing us back to rethink, to reorganize, to orient ourselves, to repackage ourselves, to document ourselves, to network with the Ministry of Justice and whatever. Because when you look at Justice Amoko's presentation, they were highlighting issues of detailed situations and actually creating confusion in the justice sector. We cannot have, but we are running away. What am I saying? I'm requesting humbly that I appreciate Dr. Walusimbi's presentation, and I think you were so candid, and you and Dr. Zahara, you owe us a lot by taking it up. Make orientation training programs for our Sharia graduates, sheikhs in this country. I have been one of the persons working closely with the directors of Sharia. And at one time, we were challenged by Justice Kakoza, the late. He wrote a letter wanting a list of graduates of Sharia in this country. I was among the people who actually profiled these guys. But I found a lot of challenges. In fact, Doctor, if you were to look at that file, you would, first of all, go back before you actually argue for all these kind of things. Having said that, I have also noted that of recent, there are some strides made by the Director of Sharia. In fact, when Dr. Zahara was presenting, she seems to be a little behind the schedule of what has happened. I would have wished the Director of Sharia, represented by the registrar here, to come up and give this audience some bit of updates, because they have gone some steps ahead, and I think the public needs that kind of information. I thank you so much.
Okay. Please, gentlemen and ladies, the remaining 2 people I'm going to be giving a chance, ask a question, all right? If you want to make a comment, be candid, all right? So that we can save on time, for another, session that's going to come in. Yes, sir.
Assalamu alaikum wa rahmatullahi wa barakatuh. My name is Bano Yassin, a postgraduate student from from Islamic University in Uganda, and I'm happy to tell you that Dr. Abdul Hafid is among my supervisors. I'm a sheikh, and only that I'm not a specialist in law, but I'm specializing in Arabic literature. Mine is an observation and high support to the words of Dr. Abdul Hafid. I'll start by saying that enhancing access to family justice.
Do you have a question to ask?
It's an observation.
Okay.
Yes.
Make it be candid, yeah?
Enhancing access to family justice. This issue here is very elaborate in the Holy Quran. The Holy Quran has elaborated all of these issues relating to enhancing access to justice. Allow me quote the words of the late Muammar Gaddafi, who said that Al-Qur'anu Shari'atul Mujtama, that Quran is the best law for our communities. Why? Because it is the only book that can't be corrupted. Let me quote for you some verses of the Quran. Allah subhanahu wa ta'ala says, وَإِذَا حَكَمْتُمْ بَيْنَ النَّاسِ أَن تَحْكُمُوا بِالْعَدْلِ. If you issue justice among people, you should be just. This is a verse from the Quran. وَعَاشِرُوهُنَّ بِالْمَعْرُوفِ. When you are living with our spouses, you live them in cordial, good relationship. So these are verses from the Quran. Rasulullah says, خيركم لأهله ليس منا من لا يرحم صغيرنا ولا يوقر كبيرنا. All these are elaborate from the Holy Quran and the traditions of the Holy Prophet. So what am I trying to say? That if our other partners, our other colleagues and brothers in the other side of the law are informed about the Sharia law, let us engage our experts for us to be informed. Thank you very, very much.
Okay. I will, the lady there, I'll allow 2 more people, provided you have a question. Don't make supplement, eh? These people have done justice to the papers. I want people who have got some issues to be sorted out. Yes.
Thank you, Professor and panelists, for the detailed analysis. My name is Justice. I work with LASPNet. Mine is a recommendation. I realized one of the challenges was ignorance of the judicial officers as regards Sharia law. Is there a way we can preempt or organize a conference as Muslim Center for Justice and interest judicial officers, not only in the Muslim community, but the entire judiciary, and interest them with Sharia laws and the substantive Muslim laws? Maybe that can help to mitigate that challenge. Okay. Thank you very much.
Welcome. I want 2 hands up, on condition you ask a question. If you're not asking a question, I will stop you. I want these people to respond. Yes, sir. Question.
Thank you, Mr. Chair. Mine is a question. I'm Ziwa Ashraf. I'm sorry I came late, but from what Dr. Zahara was presenting, it worried me. So the question is, from your, please, Doctor, it appears your research was painting a gloomy picture of Sharia law. Is it Islam or the Sharia law which is denying family justice, or it is we Muslims who have failed to practice family justice? So help me that.
Very good.
Thank you.
Another question? One more question. Question, eh? Yes, sir. Behind you there, in the corner.
Yes, thank you. My name's I'm Shafiq Yahweh from Thuraya Islam Media. So according to the presentation, my question is, how are we going to synchronize? Because I think justice is made out, laws are made because you go to certain courts because you believe the laws that are made there. So if a person believes Sharia, he will go to Sharia courts. If the person believes in the Constitution, he will go to the Constitution Court. So the question is, how are we going to synchronize the two courts so that a person feels comfortable going to either of the courts without any hesitation? Thank you.
Thank you. I think that one will be answered by Dr. Abdul Hafiz. Take on that one. So I want to close the questions. Now I want to call upon the panel to respond to those questions, and then we shall close the session. Dr. Zahra, please.
Thank you very much for the comments from the floor. I think there is a new challenge to me. I thought I was done with books. I thought I have enough, but maybe I will go and get a diploma.
Yeah, please.
But that aside, I want to clarify that at no point in my presentation did I say that Sharia law is lacking. Sharia law is the ultimate law. I, however, emphasize the fact that whereas Sharia law is in place, we have gaps within the enforcement or implementation of it. And I gave the example of the acceptance to have more than one wife, which is a right of Muslim men. And the Sharia law, the Quran is very clear. It says marry 2 or 3 or 4, but if you're unable to do justice by them, then marry only one. It doesn't hurt for us as experts on Sharia law to sit down and think through, for us as a Muslim community in Uganda, within our context, what is justice? What is justice? What would be just to wife number 2 and wife number 3? Those are the things that I think will help us to achieve access to justice for every member of our community. Council Nakacha also gave the example of the settlement after divorce. How do you define a gift? Sharia law is good, but can we as experts sit down and deliberate? We don't have to take away from Sharia, but we can add that detail, that procedure. We have the Qadi courts under Article 129. Who are the persons eligible? When can they sit? How can they record the cases? You know, what is the minimum? So that we can have things that guide and further allow us to have access to justice. So that is what I wanted to emphasize. So with regard to Ms. Shemeri from Center for Domestic Violence Prevention, I think what we are saying, and we are all saying the same thing here, we need to advocate for some codification. I don't think as a Muslim community we are disagreed on having a Muslim personal law. No. We actually already have a framework, a structure in place. Can we improve this as experts, you know, as Islamic experts, so that we can assist our people? I'd also like to say very quickly on the issue of justice. Dr. Umar, you mentioned that all communities have their own understanding of justice. Is justice above human rights, or is human rights above justice? Now, justice is a very subjective concept. What is just in one community may not be just in another. So if we allow these variations of justice, in the Karmajong culture, if you go to fight for cattle and you kill a boy, a son, reconciliation can only be met if you kill the son from the other clan which was fighting. Is that the justice we want? As a Muslim community, I think we should be working towards standardization, uniformity, general understanding of the rules of Sharia, interpreting what the Quran has said and trying to document it. I think that is what I'm emphasizing here. But in no way did I say that we need to take away from Sharia. With the human rights, for example, the issue of puberty, yes, Islam says marriage at puberty, well and good. But other law says 18. If the girl is ready at 12 or 13, but look at our context in Uganda. If she can wait for another 4 years, is that a problem? Is she ready? There is a basis. You know, Islam also works with science. If the girl has reached puberty at 12, will she be able to have a baby? So I just want us to open our eyes as Muslims, part of the community, to say that yes, we have Sharia law, but how do we reconcile with other systems? How do we build on? How do we build the rules and the procedures so that we have better clarity of our laws and thereby working towards access to justice? Thank you very much, Chair.
Dr. Abdullah Hafiz, you have got some responses to make. Please go ahead.
Thank you very much for the question, Mr. Yahweh, that the question you asked. How can we harmonize or synchronize the Sharia approach to justice and the conventional or the civil courts approach? My contention is the line between the two is very thin. The two legal regimes can easily meet and agree. When we involve the brains that matter, I can assure you that we can agree and therefore we can harmonize. But what are the practical steps? Where should we start from? By the way, most of the issues that have come from the presentation and the discussion, it is a responsibility of the government to take on these issues. The Muslim community in Uganda, it needs to be judged by Islam. So what are the practical steps? One person has, one of the contributors has said that, can we think about bringing the judicial officers together so that they can get a dose of Sharia? Yes, it is possible. I had my PhD from Pakistan, and there is an establishment known as Sharia Academy. And every year it meets all stakeholders in the laws of Pakistan, so that they can be oriented, they can be trained. But the challenge is, who is supposed to take on that responsibility? So, in my own view, I think the state, it has a role to play in this. It is its responsibility. It is the state which allowed Article 129 to be in the Constitution, and therefore, maybe ours is to advocate so that it can see some light. Now, other issues that we are talking about, they will come on board once this is operationalized. The issues of codification of Sharia. You know, what is taking place in Kenya, for instance? In Kenya, they have Qadhi's courts. And these courts are supervised by the judiciary. So what's the problem here? It is possible we can benchmark from them, and like Council, sorry, I'm forgetting her name. Yes, like the way she said, Rome was not built in one day. And in Sharia we say, Masiratu alfu mil tabtadi bi khatwa. The journey of 1,000 miles starts with a step. If they can make it, if Kenya did it, why can't we do it? Why can't we did it? Professor is correcting me. You know? So, the moment we have that in conclusion, I can assure this congregation that all issues can be addressed, even the issues of gender, for instance. Islamic law has an approach for gender inclusion. The approach of Islamic law is to assign responsibility to the one who does it best.
That's the principle.
If the best person around in terms of Islamic law is a lady, I can assure you Islamic law has no problem to assign her as a qadi, but create a conducive environment in which she can take on that responsibility. That's the approach of Islamic law. So it's not about male dominance. No. I'm not going to employ a male person simply because he's a male. No. It is about qualifications. Once we want to find those qualifications in the female, it is female issue. It is on merit. Professor here on my right hand will bear testimony that in Malaysia, that's the trend. Who are the leaders, who are the vice chancellors of big institutions in Malaysia? There are many women who are there because it is a matter of qualifications. So the moment we have that, the moment we have the Qadhi's courts operationalized, the moment we bring the better brains and the competent ones on board to meet the judicial officers from the other side, I can assure you that we can harmonize. I thank you very much.
Thank you very much. I know we have been talking about the Qadhi's courts and so on and so forth, and somebody was saying we first bring the manpower and then we can ask for the courts. I would rather differ and say give us the courts and we provide the manpower. Anyway, there are some people who are online and there are comments. I would want to give them an opportunity to also join and be part of this conversation. I don't know whether the technical team there can relay their concerns and then we can hear from them as well.
Maybe we can just read the comments.
Okay.
There's one from Ian Dolan. Interesting point about marrying at puberty. In the modern world with better nutrition, etc., puberty is starting much earlier, even in some cases at less than 10 years. So is there a need to align the two positions? Then another comment.
Dr. Abdulhafiz will answer that question.
Others were more comments.
We've got Dr. Mayanja here.
If the Muslim...
MashaAllah, he will also answer some questions, I think. Okay, go ahead.
There's another one from Sebaiga Abdul. If the Muslims had changed in leadership, especially bringing young people on board, all these discussions on how Muslim law can be operationalized would have been handled. But thanks to the Muslim Center for Justice.
That's an observation, I think.
Then the last one, thank you so much, panel. You all did justice to today's theme. The Muslim community can only do better. Tahia Naseje, the Human Rights Center, Uganda.
Okay.
Those are the comments that we have. So,
Thank you very much for those people on the online community. We are very proud of you out there, and we know you are following us very well. Please keep tracking. Don't go away. We are really engaging, and this is very powerful. I want to call upon Dr. Abdulhafiz to answer the question. And if you feel Dr. Mayanja Sowaid is also another expert in Sharia. He wrote a book on inheritance. Some of you who say don't know what those things are, he has a book on inheritance in English, exactly. Right? So get a copy. I mean, I got a copy from him some 6 years ago. So, yeah.
So, Mr. Chairman, through you, I could request that our senior expert in Sharia, Dr. Sowaid, should make some few comments, inshallah, after my comment, because actually he's our senior person in terms of Sharia.
Yeah.
Now, on the issue of puberty, yes, puberty starts early, and it varies from one environment to another. It has many other factors that can contribute to it. The feeding, the water, and so on and so forth. So it starts early. Now, the concern of the person on online is, since it's starting early, then there is need maybe to look at it so that we do not give away the Muslim daughters at that early age. The response is, I think it is a misconception to bring together puberty and marriage. It's a misconception. When the lady, for instance, attains puberty by going into menses, what does the biology people say? Is she really ready to bear the child or to take on the responsibilities of the pregnancy and others? Is she psychologically ready, among others? So, we should not mix things that the moment this woman hits puberty, this young girl hits puberty, therefore direct to marriage. Not at all. In fact, when you look at the Islamic scholarly opinions on maturity by age, you find out that some of them have said 16, 17, 15, 14. And you see that it is almost closer to the 18 that is provided for under our Constitution. And that's why I'm saying, that's why there is need for the legal brains from both legal regimes to meet. And I know that they can agree. So, when we talk about puberty in Islam, it is actually a wake-up call for the parent that take care. Should this young lady be left just to mix up anyhow or what, you should know that it is a sign that she can conceive. But there is no any way that Islam says that the moment you have puberty, direct to go to marriage. The same Islam says, طَلَبُ الْعِلْمُ فَرِيضَةً عَلَى كُلِّ مُسْلِمٍ. Seeking for knowledge is an obligation of every Muslim lady and Muslim man and woman. Now, don't you think that marrying her at that age, it is a sabotage to this hadith? That's why I always say that when we read these Islamic regulations, we also need to read them together with others so that we can find a way forward. Thank you.
Thank you very much. In the interest of time, I'll just give Dr. Mayanja 2 minutes to make a comment. Not on any specific question, but, you know, Dr. Sowed Mayanja is the Imam of Makerere University. He's a person who taught at the Islamic University in Uganda, and then he went to Zanzibar, and he's a legal expert in both laws, right? Islamic law and the Sharia law. So, Dr. Mayanja, please, can you give him a mic, and he can use 2 minutes to make a comment on what's going on here.
Program Guide is brought to you by StarTimes Go, the largest shopping mall on our TV screen. Program Guide. Catch the UEFA Nations League and La Liga live on StarTimes. Upgrade to Classic or Smart Bouquet for 28,000 shillings.